speaker and video will be
more in crisis than in comfort. Good evening to all of you present over here. On behalf of Dhyan, I welcome all of you to this beautiful evening. Quarantine, a totally new experience. No schools, no colleges, no offices. Just stay at home. Yay! This was the first reaction of all of us present over here, quickly followed by, nay, so boring. So, to kill and drill this boredom, Dhyan has come up with an idea to conduct lecture series. Today is the second session of the lecture series, and the topic for today is Judicial Review under Indian Constitution by the esteemed speaker Pallavi Devi, who is an assistant professor of law in Gauhati University. Pallavi Devi did her LLM from Gauhati, and her core area of interest constitutes of constitutional law and administrative law. I would like to highlight that she is a UGC NET qualified and has submitted her PhD in Department of Law. We welcome you, ma'am.
Thank you, Ms. Astha. First of all, let me put in record a big thank you for inviting me to this lecture series by Dhyan. Dhyan is an educational institution since 2005, giving classes to CLAT and Judicial Service aspirants located in Kolkata. The topic that I am going to speak is Judicial Constitution of India. So this lecture, I will be dividing into 3 units. The first part, I will deal with the definition, origin of judicial review, and the provisions where in Indian Constitution we can find the doctrine of judicial review. Second, I will bring out the contours of judicial review. That is, I will bring the broad outline of judicial review, and we'll keep on focusing the tug of war between the legislative and executive on one hand and the judiciary on the other hand. And third, how the concept or how the doctrine of judicial review have or how the doctrine of judicial review have enhanced the philosophy of legal aid movement in the judicial process.
Now, even though judiciary is considered as an independent branch of the government, yet all the 3 organs of the government work in harmony,
and therefore they are not brought as superior or inferior to one another. Rather, they are considered as equal and coordinate branches, respecting the doctrine of separation of power introduced by Montesquieu, and also respecting the checks and balances, because it is only by checks and balances that a constitutionalism will be maintained. Where there is no constitutionalism, the constitution is likely to fall. Now, by separation of powers or by checks or balances, this would mean that the legislature can encroach upon the power of the judiciary. Executive too cannot encroach upon the power of legislature and judiciary, and vice versa. Then, a question arises in this scenario. If there is so much of separation of power or checks and balances, then to what extent judiciary could look into the validity of laws made by the parliament and the state legislatures or the legislature of state. Now, this is a very important question, because judiciary is independent, and how would judiciary assert its independence? Because the other two, in the other 2 branches of the government, there is a connivance between the legislature and executive. So this very question throws the light of existence of a confrontation between the Supreme Court on one hand and the legislature and the executive on the other hand. So here I would like to bring the preamble of the Indian Constitution, who declares India to be a sovereign, socialist, secular, democratic republic. And I want to focus on the word socialist in the context of the topic. The Supreme Court of India, in many cases, has observed that its principal aim of being a socialistic country is to remove poverty, garibi hatana, and to provide a decent standard of life to the working class people. Now, how would this socialistic meaning be achieved? This means that the state legislature have to pass land reforms by bringing agrarian reforms. Land reforms means that land in excess of ceiling will be taken over by the government from the zamindars to distribute to the landless. This would mean that the land would go to the tillers of the soil, and the zamindari system should be abolished. And what would the center do to achieve the socialistic meaning of the Indian Constitution, which is a preambular mandate? The center have to nationalize bank to bring the bank into their control, thereby giving the workers or empowering the workers to have equal opportunity, and by abolition of vested interest. Now, abolition of vested interest means cutting the businessman to size. And this is what the Constitution of India wanted the executive to do. But while bringing out land reforms, the executive, in particularly bringing out the land reforms, they sided with the government. And when you look to the provisions of the Constitution, like Article 339, Article 339 also mandates to bring welfare to the downtrodden people, or illiterate people, or the economically weaker section of the people, underprivileged people. But instead of bringing reforms, the parliament ignored this concept, which is capable of bringing social justice. The parliament, instead of bringing reforms, what they did is that they brought amendment. They strike down laws which are capable of bringing land reforms. They strike down the agrarian statutes. And even Nehru, who was the first prime minister, held that judges should come from the ivory tower and sympathize with the legislatures, which had 1,000 urgent things to do, which are urgent actions for the deprived section of the people. And it is the parliament and not the judiciary who represents the will of the community. And when the future of the community is concerned, no judiciary, higher or lower, can come in between. Thus, the parliament kept passing amendments, and there were 20 amendments in the Constitution of India till 1966. Also, judiciary till Goloknath till 1966 did not adopt a more liberal and progressive outlook, and therefore they declared property as a fundamental right. Fundamental right means that is beyond the reach of the parliament. Parliament cannot amend it. And when property is a fundamental right, the restriction of having the land in excess of the ceiling is blurred. Now, judiciary have seen that they were being undermined. Let's not forget here that the founding fathers of the Indian Constitution have envisaged the Supreme Court also to be an arm of social revolution, and that national goals enshrined therein in the Constitution were addressed as much to the judiciary as to the legislature and the executive. And therefore, the judiciary was not prepared to keep quiet. They felt that they were undermined to a large extent. So what they did is that they used the power of judicial review in Goloknath case in 1966 and held that the power to amend the Constitution should be there in the words of Article 368 itself. But Article 368, before 1966, deals only with the procedure to amend the constitution, and the power to amend the constitution was absent. Each one of the 20 amendments that took place till 1966 was done with the help of Article 13. And Article 13 is an ordinary law and not a fundamental law. And if it is not an organic law, the law has to be detested against fundamental rights. And if we look to Article 13, we will see that the main object of Article 13 is to secure the paramountcy of the Constitution as a higher law in regard to the fundamental rights. Now, the first clause of Article 13 declares that the pre-constitutional law as void, to the extent they are inconsistent with fundamental rights. The first clause of Article 13 declares pre-constitutional laws as void to the extent they are inconsistent with fundamental right. The second clause of Article 16 relates to post-constitutional laws. Now, the Article 13 clause 2 prohibits the states from making a law which either takes away totally the fundamental right or abrogate partially some fundamental right. The state prohibit from making a law which is against the fundamental right. So the aim of Article 13 is to uphold the Constitution as a superior law, and therefore the judiciary in one stroke strike down the entire 20 amendments that has been passed till now by the parliament. Now, how can the judiciary strike down all those amendments which were passed till now? Altogether, there were 20 amendments till 1966. Let me here also bring into your knowledge that the Constitution of USA, they had only 20. The Constitution was till now is amended only for 27 times, and the Constitution of USA came in force in the year 1789. But if we look to the Constitution of India, which came into force in 1950, until 1966, we already have 20 amendments. So this is the difference. Now, what could be the result of striking down the 20 amendments that has already been passed? Now, is this possible? And if it is possible, what will be the result? The result is that if judiciary can strike down the 20 amendments, then the tillers of the soil should give up the land to the zamindars once again. And the zamindari system that was abolished will crop up once again. This would really create a mayhem. But in this background, judiciary very wisely held that Guloknath case would have only prospective overruling. Means after 5 years, it will not have a prospective ruling, but it will have a prospective ruling. And this concept of prospective overruling is indeed an innovation from the end of judiciary. And thus, the judiciary saved all the early amendments. Now, judiciary has made it clear that Article 368 consists only of procedure for amendment and does not have the power to amend. This is a very good example of the tussle that is going on between, or that goes on between the parliament and the executive on one hand and the judiciary on the other hand. Therefore, the parliament by 24th amendment in 1971 amended Article 368 to substitute the word procedure for power of the parliament as power of the parliament to fight against the legislature or the executive. And thereafter, so far the Supreme Court was concerned, they started a new era of judicial activism to show that they are really independent, that they are not under the shadow of the two other organs of the government. And thus, that is, the PIL was born. PIL means the public interest litigation. Now, what is this PIL? Where the illiterate or the economically weaker sections of the society, the downtrodden, need not come out. If a lawyer or an NGO saw their condition, they can bring their grievances to the court, and the court will not ask why the person concerned is not coming, or why the person concerned has not come to the court. So this is in fact a great pity. Therefore, this PIL revived and renewed the hope and faith of the poor once again in the judicial process. Now, this remedy of PIL is credited now to Justice P.N. Bhagwati and Justice Krishna Iyer to be the forerunner. For example, if we look to Husainara Khatun versus State of Bihar, we will find that the Supreme Court of India has freed several indigent under trial prisoners, where more than 22,000 prisoners, under trial prisoners, were confined in jails beyond their period because they could not give the security that is necessary to get the bail, as they were too poor to furnish the bail. So, speedy trial is an essence of the criminal justice system. Likewise, we also find in Sunil Batra, where the epistolary jurisdiction was exercised by the Supreme Court there, where a prisoner's letter was treated as a writ petition. We also find similar cases like Sila Borse versus State of Maharashtra, where a letter was written by a journalist alleging custodial violence of women prisoners in jail, addressing to the Supreme Court. Treating the letter as writ petition, the Supreme Court took cognizance of the matter and issued directions to the concerned authority. Similarly, in Ratlam versus Verdician, where the court admitted a writ petition filed by a group of citizens who sought directions against the local municipal council for removal of open drains. You see, the jurisprudence of human right has been broadened. So this era, after Keshavananda Bharti, one second. So this era became a new era for judicial activism, and this era broadened the framework of human rights jurisprudence. And thus we find many different jurisprudence like Dalit jurisprudence, gender jurisprudence, environmental jurisprudence, consumer jurisprudence, medical jurisprudence have emerged, where the judiciary is considered as a protector of the rights, or where the judiciary is considered as an arm of social justice to the needy or the common people. In the doctrine of judicial review, another article is very important. That is Article 142 of the Indian Constitution. Article 142 talks about enforcement of decrees and orders of the Supreme Court. This is indeed a great source of power. And we should not forget about Article 141, where any law, judgment declared by the Supreme Court of India becomes the law of the land. Another weapon is constitutional morality that has been built in the entire constitution to protect the spirit of the constitution. Now, this weapon of constitutional morality, this was used by Dr. B.R. Ambedkar when he was drafting the constitution. But today, constitutional morality has been used as a weapon to protect the spirit of the constitution, because we keep on finding that the tussle between the executive, the tussle for power between the executive and the parliament and the judiciary is very much visible. Of course, judiciary do need to exercise abundant caution not to encroach other organs of the other organs. So I would like to conclude with the words of Justice Savant. The rule of law is the foundation of a democratic society, and the judiciary is the guardian of the rule of law. Judiciary is not the third pillar, but rather judiciary is the central pillar of a democratic state. Law and justice, they should not be stand at a distant. They should not stand at a very much in distance. Rather, they should be in a very talking terms to each other. Otherwise, how will the rule of law be protected? Thank you. Over to you, Astha Singh.
Thank you, ma'am, for this beautiful lecture. What a wonderful session we had today. Ma'am, we look forward to have you again for some of our future lecture series. And once again, thank you for taking out your valuable time and joining us as a speaker. Last